It's Chief Justice Mogoeng Mogoeng's last day in office today after his 10-year term at the helm. Mogoeng was appointed back in August of 2011 by former President Jacob Zuma. He's, however, been on leave since May as the search for his successor intensifies. For discussion now on the outgoing Chief Justice's legacy, we're joined by Mbekezeli Benjamin. He's with the organization Judges Matter, a researcher there. Mr. Benjamin, thank you very much for your time. Just overall, if one were to ask the question, how do you think Mogoeng Mogoeng's legacy will be remembered as this country's Chief Justice, how would you sum it up?
Good morning, Nkandla, good morning to the viewers. It's a complex question without a simple answer. But I can try and say his legacy is a mixed bag. There are some good parts of it that he put forward, and there are some parts that I wish maybe could have been done differently. The most significant part of his legacy is perhaps the legacy that he leaves the judiciary as an institution a little bit more stronger, although there are some weak points. You'll remember at the beginning of his term of office, the judiciary, the High Court judiciary, still fell under the Department of Justice. And so it was his task to set out an independent judiciary that can administer the courts, and the judges will have the final say over the courts. And he's tried part of that. There's a national government department now that is responsible for that. He's also set out a written code of conduct for judges, which didn't exist before. There's also now a written set of norms and standards which guide how courts should perform. So those are some good parts of his legacy. The bad parts perhaps are his public statements, which have tarnished his legacy. He's the first Chief Justice, for example, to have been found guilty of breaching the code of conduct. And so that is part of his legacy that is the bad part. But overall, he leaves a solid legacy, I think.
Yeah. Let's talk about the decision to take 5 months leave, which ultimately leads to his exit. How should the public read this?
I think we should read it as a failure of leadership in a way, because that was the past 6 months have been a very crucial time in our judiciary. The Constitutional Court, for example, has been under severe pressure and has had to deal with some difficult and complex cases, the elections case being one of them, but there were several others that came through that needed someone with solid hands to guide the ship, so to speak. And he was missing in action. The Judicial Service Commission did interviews in April. Those interviews were challenged in court successfully, and they had to be rerun. The person who was in charge of that process was missing in action. And so he left at a really crucial time for the judiciary. And yes, there is something, well, some people are saying that, look, he would have forfeited his leave if he didn't take it. But look, 6 months of leave versus he still has a number of years where he could have taken the rest if he needed the rest, but it was not at the right time. His timing was really bad.
And this decision around his leave, which was taken in May, Mr. Benjamin, it came at a time when the Constitutional Court was preparing to hand down its judgment on whether the former president should go to prison for contempt of court. What should we read into that? Is there something to read into it? Some might say read between the lines. Or are we making too much of this decision to take leave at such a crucial moment?
I don't think there's much to be read into his decision and the Zuma case, because the case he wasn't even part of the case to begin with, but it was done by the justices of the Constitutional Court, who all are impeccable jurists in their own right, and they were guided by the law, and they took a decision that was difficult, but it was a decision that they came to with an understanding of the law. Perhaps the presence of the Chief Justice could have maybe I'm not sure what it could have added or it takes away from that decision. I think it's a decision that stands on its own. The Chief Justice, I think, he took leave based on considerations that are beyond that particular case. I think it was something that he decided on, I'm guessing ahead of time, and it was a decision all on his own. The court stood and the court made a decision, a difficult decision, with or without him. So I don't think we should read much into it.
Yeah, you spoke about his legacy being possibly described as a mixed bag. At least that's your view. Let's talk about perhaps one judgment that will stand him in good stead, when many people, right at the time of his appointment, expressed doubt. But the Nkandla judgment of 2016, how do you think that is going to go down in history? Is that one of his memorable judgments, you think?
So that Nkandla judgment is actually an interesting one because it has come under severe academic criticism. Many academics, legal academics, are saying that it was not the most legally sound judgment, but in terms of its political impact on our country and on our democracy, I don't think anyone can deny that it was an important moment. It used very strong language, cutting corruption at its neck. That kind of language was necessary at the time because we were reaching a point where some say our democracy was almost lost. And so I think him making that judgment, making those strong statements at the time was crucial to our democracy. And so if you look at it politically, it was an important judgment, although there is some legal criticism of the judgment.
Talk to us a little bit about that legal criticism.
So some academics are saying that the finding that the public protector's powers are binding was not, in fact, intended by the drafters of the Constitution. They intended the public protector's powers to be a lot more than just mere recommendations. They were stronger than that, but they don't rise to the level of a binding order akin to the order of court. And so the Concord's finding on that issue, they say it wasn't strongly reasoned legally, and so there is some debate about it, and perhaps in future cases the court might revise it or might explain it in a different way, but that's just one strand of the criticism.
Mbekezeli Benjamin, thank you very much for your insights here. He is a researcher with the organization Judges Matter.